In the summer of 1917, King George V of the United Kingdom made a decision that his cousin, Tsar Nicholas II of Russia, would later pay for with his life. Nicholas, his wife, and his 5 children were being held under arrest by the Bolsheviks, who had seized power in the revolution. The British government had offered the Romanovs political asylum. George V withdrew that offer. He withdrew it because he was advised that the presence of the unpopular Tsar in Britain during wartime would be politically damaging to the British monarchy. The Romanovs remained in Russia. In July 1918, they were executed in a cellar in Yekaterinburg. George V's role in withdrawing the asylum offer and the specific calculation that his advisors made about the political risk to the British Crown of sheltering his first cousin's family was not made public at the time. It has since been documented by historians. It has never been the subject of a formal royal acknowledgement. In this video, we are counting down 12 times the British royal family did something nobody talks about. Not the tabloid stories, not the personal scandals, the documented historical decisions, the institutional actions, and the specific choices made by the people who occupied or served the British throne, that have been quietly filed in the category of things that official royal history prefers not to foreground. Stay with me to the end, because number 1 is a chapter of royal history that involves a British king, a Nazi regime, and a set of documents that the British government has been managing the release of, very carefully, for 80 years. So hit subscribe, turn on notifications, and let's begin. In March 1917, following the First Russian Revolution, the British government extended a formal offer of political asylum to Tsar Nicholas II, his wife Tsarina Alexandra, and their 5 children. The offer was made partly on humanitarian grounds, and partly because of the family relationship between George V and Nicholas II, who were first cousins. Alexandra was also a granddaughter of Queen Victoria, making her a close relative of the British royal family. Within weeks, the offer was withdrawn. The withdrawal was not the result of a changed security assessment or a Bolshevik objection. It was the result of political advice to George V that the presence of the unpopular Tsar, associated in the public mind with autocracy and with the failures that had brought Russia to revolution, would be damaging to the British monarchy at a moment when Republican sentiment in Britain was not negligible. The King's private secretary conveyed the royal concern to the government. The asylum offer was withdrawn on the basis that it might harm the British Crown's public standing. The Romanovs remained in Russia, passed between locations by successive revolutionary governments, until the night of the 16th of July 1918, when the Tsar, the Tsarina, their 4 daughters, their son, their doctor, their cook, their footman, and their maid were shot and bayoneted in the cellar of the Ipatiev house in Yekaterinburg by a Bolshevik firing squad. George V did not attend the memorial service for his executed cousins. The royal archives contain correspondence documenting the withdrawal of the asylum offer. The official royal biography of George V, published in 1952, does not discuss this episode with the directness that subsequent historical research has established is warranted. The abdication of Edward VIII in December 1936 is one of the most documented events in 20th century British royal history. The official account focuses on the constitutional crisis created by his determination to marry Wallis Simpson, an American divorcee whose marriage to the king was deemed unacceptable by the Church of England and the British government. Edward abdicated, became the Duke of Windsor, married Simpson, and lived in exile for most of the rest of his life. The Nazi dimension of the abdication story is significantly less prominent in the official account. In the summer of 1937, Edward and Wallis Simpson visited Nazi Germany. They were received by Adolf Hitler at Berchtesgaden. Edward gave the Nazi salute on multiple occasions during the visit. Photographs of these events exist and have been published. The visit was controversial at the time. It has become more controversial as the documentary record of Edward's attitudes toward Nazi Germany has expanded. Documents from German diplomatic archives captured after the Second World War include material suggesting that senior Nazis believed Edward was sympathetic to the regime and that his abdication was in some respects convenient for those in Britain who did not share his sympathies. The Windsor File, as some of the relevant German documents came to be known, was the subject of diplomatic controversy when it was first published in 1957, with the British government and the Duke of Windsor both seeking to suppress or limit the publication. Some documents relating to Edward's wartime activities and his contacts with the Nazi regime remain classified or have been released only in redacted form. The full picture of Edward VII's relationship with Nazi Germany has not been made available in an unredacted form by the British government. Between 1952 and 1960, the British colonial administration in Kenya conducted a counter-insurgency campaign against the Mau Mau uprising that involved systematic detention, torture, and killings of Kenyan civilians on a scale that British governments denied for decades, and that was documented in detail by historian Caroline Elkins in her 2005 book, Imperial Reckoning. The Kenya Emergency, as it was officially called, took place under the authority of the British Crown and was conducted by the colonial administration in the name of the Crown. The specific question of what members of the royal family knew about the methods being used in Kenya and whether any royal knowledge of or proximity to the emergency extended to knowledge of the specific abuses has never been the subject of a formal investigation. Queen Elizabeth II was on tour in Kenya when her father George VI died in February 1952, making her accession to the throne directly associated with the colony where the emergency would shortly begin. The British government paid compensation to Kenyan survivors of abuse during the emergency in 2013, acknowledging for the first time that the abuses had occurred and that the British government bore responsibility. The settlement was described as an expression of regret rather than an apology. The documents relating to the Kenya emergency that were secretly removed from Kenya before independence and held in a government facility at Hanslope Park were not disclosed until 2012, when a court case brought by Kenyan survivors forced their partial disclosure. The full archive has not been released. The Crown Estate owns the seabed of the United Kingdom out to the 12-mile territorial limit. This is not widely known by the general public. The Crown Estate is a public body that manages property on behalf of the Crown, and its revenues are surrendered to the Treasury under a framework established by the Civil List Act and the Sovereign Grant. The ownership of the seabed by the Crown Estate has become significant in the context of the offshore wind energy industry. The rights to develop offshore wind farms are granted by the Crown Estate, and the Crown Estate charges rent for the use of the seabed on which the wind farm foundations are placed. The revenue generated by the Crown Estate from offshore wind leases is substantial and growing as the UK offshore wind industry expands. The framework under which the Crown Estate generates this revenue from the offshore wind industry, and the question of whether the arrangement represents good value for the public, given that the Crown Estate's ownership of the seabed has its origins in medieval royal prerogative rather than in any purchase or democratic allocation, is a question that the political and media discourse around offshore wind has not engaged with as directly as the question of energy prices and planning permissions. The Crown Estate paid £4.1 billion to the Treasury in 2023-24. The amount generated from offshore wind leases is a growing portion of this. The seabed that generates this revenue was not bought, it was inherited. The medieval royal prerogative that established Crown ownership of the seabed has never been subject to democratic review. The Duchy of Cornwall is a private estate that generates income for the heir to the throne. It owns approximately 135,000 acres of land in England, primarily in Cornwall and the southwest, and generates annual revenue in the tens of millions of pounds. The duchy is managed under a framework established by legislation and its tax position has historically been that the heir to the throne pays income tax on duchy revenues voluntarily, following an arrangement established in 1993 by Prince Charles, later King Charles III. The word voluntary in the context of the taxation of one of the most significant private estates in the United Kingdom is one of the more remarkable formulations in the public discourse about royal finances. The Duchy of Cornwall does not pay corporation tax on the basis that it is not a corporation. It does not pay capital gains tax on the basis of its specific legal status. The heir to the throne pays income tax on duchy revenues on a voluntary basis. The arrangement means that the taxation of a major private estate, generating tens of millions of pounds annually, is determined by a voluntary decision rather than by the tax framework that applies to every other private estate in the country. The duchy's landholdings include properties in areas where housing affordability is a significant policy issue. The relationship between the duchy's landholding decisions and the housing availability in those areas is a question that the duchy's tenants and local planning authorities have raised, and that has not been resolved by any formal independent assessment. And hey, before we reach the final six, if this video is showing you a British royal institution whose documented history is considerably more complex than the ceremony and the pageantry suggest, hit the like button and share it with someone who thinks they know the full story. Now, let's continue. The British royal family has historically played a formal role in the promotion of British arms exports, through the attendance of senior royals at arms fairs and defence exhibitions, through the reception of heads of state at Buckingham Palace, during which arms deals have been under active negotiation or conclusion, and through the formal visits of members of the royal family to countries to which Britain has been selling military equipment. The specific documentation of the royal family's role in the promotion of British arms sales is available in the public record, in the formal court circulars that record royal engagements, and in the parliamentary records of arms export licenses issued to countries that were the subject of concurrent royal visits. The sale of British arms to Saudi Arabia, which has been the most significant and most contested British arms deal of the late 20th and early 21st century, has been conducted across a period during which multiple royal visits to Saudi Arabia took place, and during which senior Saudi figures were received at Buckingham Palace. The legal challenges to British arms sales to Saudi Arabia, which have argued that the sales should have been suspended when Saudi Arabia was found to have been in breach of international humanitarian law in Yemen, have not engaged with the specific question of the royal family's promotional role in those sales. The role of the British monarchy in the promotion of the British defence industry is a formally documented and publicly available fact that the political and media discourse about British arms sales has not consistently made central. The Koh-i-Noor diamond is one of the most famous gemstones in the world. It has been part of the British crown jewels since 1849, when it was acquired from the 10-year-old Maharaja Duleep Singh following the British annexation of the Punjab. The word acquired in the previous sentence is the word the official account uses. The governments of India, Pakistan, and Afghanistan have at various points made formal requests for the return of the diamond. Each request has been declined. The British government's official position is that the question of the diamond's ownership was settled by the legal instruments of the British annexation of the Punjab, and that any return would open questions about the broader repatriation of objects in British national collections. The Koh-i-Noor is displayed in the Tower of London as part of the crown jewels. It was set in the crown of Queen Mary, and subsequently the crown of Queen Elizabeth, the Queen Mother, in which it is currently displayed. It was worn on the crown during coronations. It is a central part of the crown jewels display that attracts millions of visitors to the Tower of London every year. The circumstances under which it came to Britain in 1849, the specific history of the annexation that made it available, and the question of whether a 10-year-old child can be said to have voluntarily transferred a gemstone that was the centerpiece of his family's treasures to the colonial power that had just annexed his kingdom, are questions that the Tower of London's interpretation of the crown jewels addresses with care. This channel covered the Peter Ball case in the video on British institutions that got away with it. Peter Ball was the Church of England Bishop of Gloucester, who was cautioned by police in 1992 for a sexual offence and subsequently convicted in 2015 of 19 offences against 18 victims spanning 3 decades. He was protected by his establishment connections across the 23 years between his police caution and his conviction. Among those connections was Prince Charles, later King Charles III, who corresponded with Ball during the period of his police caution, offered him support, and lobbied on his behalf with Church of England figures. The correspondence between Prince Charles and Peter Ball during the period when Ball was under police caution for a sexual offence was examined by the Independent Inquiry into Child Sexual Abuse. The inquiry found that Ball's establishment connections, including his connection to Prince Charles, had been a factor in the protection he received. Prince Charles was not required to give evidence to the inquiry. The inquiry found that the then Prince of Wales had been among those whose support had contributed to the conditions that allowed Ball to continue in ministry after his police caution. The King has not made a public statement specifically addressing his correspondence with Peter Ball in the period after the police caution. The survivors of Ball's abuse, who were children when Ball abused them, and who spent decades watching an abuser remain protected by his establishment connections, have not received a direct royal acknowledgement of the role those connections played. Prince Andrew, Duke of York, was a friend of Jeffrey Epstein, the financier who was convicted of sex offences in 2008 and who died in prison in 2019 while awaiting trial on federal sex trafficking charges. The Duke of York's connection to Epstein became publicly significant when Virginia Giuffre, who has alleged that she was trafficked by Epstein, named Prince Andrew in legal proceedings. The Duke of York denied the allegations. In November 2019, he gave an interview to the BBC's Newsnight programme in which he attempted to address the allegations. The interview was widely characterized by media commentators as one of the least successful public relations exercises in royal history. The Duke of York subsequently stepped back from royal duties. In February 2022, he settled a civil lawsuit brought by Virginia Giuffre for an undisclosed sum without admitting liability. The specific question of the full nature of his relationship with Epstein, the visits he made to Epstein's properties, and the circumstances under which he met the women associated with Epstein, has not been answered with the completeness that the public interest in the case would warrant. The settlement of the civil case without admission of liability means that the factual questions at the heart of the case were not adjudicated in court. The Duke of York has not returned to royal duties. He has retained his military titles, which were subsequently removed. He has not given a comprehensive public account of his relationship with Jeffrey Epstein. The people who were associated with Epstein and who allege they were trafficked have not received from him what they have described as adequate accountability. In March 2021, the Duke and Duchess of Sussex gave an interview to Oprah Winfrey in which the Duchess alleged that a member of the royal family had, before the birth of their son Archie, expressed concern about what his skin color might be. The allegation was made in the context of a wider account of the experience of the Duchess, a mixed-race woman, within the royal institution. The palace's response to the interview was a statement that recollections may vary. The specific allegation about the concern over a child's skin color was not directly denied. No formal investigation into the allegation was announced. The member of the royal family whose concern was allegedly expressed was not publicly identified in the interview, and neither the Sussexes nor the palace have subsequently publicly identified them. An independent review of the royal household's diversity and inclusion was subsequently commissioned. The review found areas for improvement. The person who allegedly expressed concern about a child's skin color before their birth has not been identified in any official process. The allegation stands in the public record as something that was alleged, that was not denied in specific terms, and that was not investigated in any form that produced a public outcome. The institutional response to an allegation of racist conduct within the royal household has been the statement that recollections may vary, a review of diversity and inclusion, and the continued non-identification of the individual concerned. The British royal family's private estates at Sandringham in Norfolk and Balmoral in Scotland are owned personally by the monarch rather than by the Crown. This means that they are subject to the normal planning law and inheritance tax rules that apply to comparable private estates, with some specific exceptions. One of those exceptions became significant when it emerged that the Queen had used a piece of parliamentary procedure called Queen's Consent to request advance sight of legislation that might affect the Crown's private interests, and had in some cases asked for amendments. Queen's Consent is an ancient constitutional mechanism, distinct from royal assent, by which the Crown is consulted on legislation that may affect the royal prerogative or the Crown's private interests. The existence of Queen's Consent has been known to constitutional lawyers. It has not been widely discussed in the mainstream political and media discourse. Reporting by The Guardian newspaper in 2021 established that Queen's Consent had been used to secure an exemption from a piece of legislation that would have required Sandringham to comply with equality laws in its employment practices, specifically the Race Relations Act 1976. The exemption was granted. The royal estates at Sandringham and elsewhere were therefore not required to comply with the equality legislation that applied to every other comparable private employer in the country. The exemption was subsequently ended when the Equality Act 2010 was passed. Between 1976 and 2010, the royal household's employment practices at its private estates were exempt from race equality legislation through a mechanism that was not publicly known. And now we have reached number 1. In the summer of 1940, the Duke of Windsor, formerly King Edward VIII, was in Portugal following the fall of France. He was on his way to the Bahamas, where the British government had arranged for him to serve as governor in an appointment that was partly intended to keep him at a safe distance from Europe. In Portugal, according to German diplomatic documents captured after the Second World War and subsequently published, the Nazi regime had plans to keep Edward in Europe and potentially to use him as a puppet ruler if Britain could be brought to terms. The documents suggested that Edward had been in contact with German intermediaries, that he had expressed views sympathetic to a negotiated peace, and that senior Nazis believed he could be useful to their plans. The British government's response to the publication of these documents in 1957 was to seek to limit their circulation. The Duke of Windsor denied the substance of the documents. The Foreign Office sought to persuade the American government, which had also captured the relevant German archives, to delay publication. The documents were published. They became known as the Windsor File. They are available in various national archives. They have been studied by historians, and some of the material relating to Edward's wartime activities remains classified in British government archives, or has been released only in redacted form. The question of what the fully unredacted British archive material about Edward VII's wartime activities contains, and why specific material remains restricted, has not been answered by any British government with the directness that 80 years of distance from the events would appear to permit. Edward died in 1972. The documents about what he did during the Second World War are still not fully available. The institution he represented, and whose interests were cited in the withdrawal of the Romanov asylum offer that opened this video, continues. The full accounting of what that institution has done, and chosen not to do, across the century that connects these two episodes, is still being waited for.